Hi, I'm Steve Danz. Thank you so much for visiting our website and our law firm, Stephen Danz and Associates, to learn a little bit more about federal false claims, or being a qui tam litigant. Qui tam is very briefly an expression meaning in the place of the king. And as we know, Shakespeare wrote a lot of plays about kings. Given that connection, I thought it would be appropriate today to talk about one of our recent cases in 3 acts and tell you a little bit about what you can expect chronologically as your case goes through each of the 3 acts. Sally was a client of ours who came in with major concerns about diagnostic-related codes or fraud in the billing in a very large medical practice she worked at. She had lots of evidence of the actual codes that should have been used, the false codes, a couple of cheat sheets where an outside consultant had showed her which codes were likely to pay more for various procedures, how to unbundle some technical things in the medical field. So we looked at the evidence. Sally was still working there at the time, and we determined that it would support a federal false claim or qui tam allegation because her clinic of 16 doctors and about 30 support staff had well over $5 million in false claims going. So we took the case and we immediately filed it under seal when that decision was made. It's important to file quickly if you have a good case, because the first to file is the first to have the right to bring the false claim case. There are some exceptions, but in most cases that is the way it goes. After the government had the information for up to, I believe it was 2 years, they had to decide whether to intervene or not intervene. They hired experts, they reserved a right to review the data later, and they chose to intervene. That was a major turning point in Sally's case. At that point, the weight of the U.S. government was on our side, and the case ultimately settled for a very large amount of money. In many cases, however, the government will decide not to intervene. And if that happens, we now have to discuss with you whether or not your case should be pursued as a non-intervened case, if there are new claims that can be brought in, and if your individual retaliation claim has legs to stand on as a litigated matter or to be settled regardless of the government's decision on intervention in the false claim. Important point to keep in mind is the government will never represent you as an individual. That is solely the job of your attorney. So we want to keep your rights for compensation, back pay, double damages, things of that nature, open for settlement and resolution, even if the government declines not to intervene and you and your attorneys decide not to proceed with the case on a non-intervened basis. Act 3 is a resolution. That is where the government determines how much the case should settle for, if the defendants are willing to pay it, if there are any set-offs on money that the government may in the future. For example, Medicare, we settled a case once where the government simply deducted from future Medicare payments in a monthly amount enough to settle the false claim. So the Act 3 is the resolution. Very, very few claims actually go to trial. These are bet the company cases, and if your case has gone this far, there are clearly significant damages and penalties that attach to it. So probably your case will settle, and we would love to be there with you at the time it does. So if you have any questions, this is educational only, not legal advice, please give us a call at 877-789-9707 or fill out our short online contact form at federalfalseclaimsattorneys.com. Thank you so much.